Friends, I am Vijay Nath Jha, advocate. I will be presenting a video series on check dishonor, do's and don'ts for common people. This is basically a legal awareness series on Negotiable Instruments Act. To start with, the first thing that comes to our mind is check. What is a check? Check is a document, it is a leaf issued by the bank to be used for the purpose of making payment. A check leaf becomes instrument only when it is filled with the payee name, date, amount, and valid signature. Then only that check leaf becomes an instrument. Unless a instrument is given to a person, is given to somebody against a lawful debt, and unless the instrument is presented in the bank for clearance, and unless it bounces for insufficiency of balance, no offense will be deemed to be committed. So here we have three things. One, we must maintain proper balance in our account. Number two, a check leaf will become an instrument only when it is filled with date, payee name, amount, both in words and in figure, and it is properly sealed and signed. Then only it becomes an instrument. The instrument should be presented in bank for clearance, and if it dishonors for insufficiency of balance, then only check dishonor takes place. When the offense is completed, what we will do? When the check is dishonored, then we have to send a demand notice to the person, to the drawer of the check, for making payment within 15 days from the date of receipt by him. If he fails to make payment within 15 days, then on the 16th day the offense is complete. Before that, no offense is deemed to be complete. The second question is ki, what if the notice is sent but it is returned back with postal endorsement, left, door closed, intimation served, not known, left without address, refused, not claimed, unclaimed? Then by not accepting the letter for any reason, please note that there are plethora of judgments of Supreme Court that says the notices sent at correct address with proper prepaid postal stamp by registered post with AD will be deemed served unless contrary is proved. So all notices are deemed served unless contrary is proved, and based on that, further legal action can be initiated. Now, what are the time limits? From the day we receive check return memo from the bank, we have to send notice within 30 days. Within 30 days, in fact, it is 1 month. And 1 month can be 31 days, 30 days, or 28 days, depending upon the month in which it happened. Thereafter, the recipient of the notice, the noticee, has to make payment within 15 days. If he fails to make payment within 15 days, then offense is complete on the 16th day, and thereafter they have to file case within 1 month from the 16th day in the court of Chief Metropolitan Magistrate or Chief Judicial Magistrate or Additional Chief Judicial Magistrate as per the jurisdiction. Here I must clarify one thing, that a check bouncing offense is a non-cognizable and bailable offense. So police does not have the authority to take cognizance of offense under check bouncing cases, for check bouncing cases. So we have to initiate legal action by filing written complaint in a proper complaint petition in the court of Chief Metropolitan Magistrate or Chief Judicial Magistrate as per the jurisdiction. Now, once the case is filed, then a preliminary evidence is conducted by way of affidavit under section 145 of NI Act, and court, upon being satisfied, summons are issued. That is the second step. The third step is the accused person, after receipt of summons, appears in court, prays for bail, and this check dishonor offense being bailable offense, bail is granted as per the court procedure. Thereafter, charges are read out to him, and the court asks the accused whether he pleads guilty, and if the accused pleads not guilty, then the trial begins. The fourth stage is evidence in chief, where the complainant has to adduce proper evidence by affidavit and then by tendering all documents, original documents on which he relies, and thereafter the advocate of the accused person cross-examines the complainant. Once the fourth stage is over, the magistrate examines the accused under section 313 CRPC, and thereafter defense witness starts. In the stage of 313 CRPC, when the accused examines the accused, he puts questions to the accused and clearly explains him that he is not bound to answer to those questions, but if he answers, then those answers may go in favor of him, may go against him. So the accused has to accordingly give his answers. In the defense witness stage, the accused adduces his evidence in support of him, in support of his ignorance, and the advocate of the complainant cross-examines him, and thereafter this stage is over. Thereafter argument takes place and judgment is passed. If the accused is convicted, then he is ordered to pay generally up to double the amount of check amount, maybe less, and imprisonment depending upon the gravity of the case from 1 month up to 2 years. So this is the entire trial process. So in this video, I have explained you the basic trial process of check dishonor case, what is check, how the notice is to be sent, and the steps of trial. The steps of trial, once again I am repeating: issue of notice, filing of complaint and taking cognizance, issue of summon, appearance of accused and pray for bail, then plea, evidence by the complainant and cross-examination of complainant, examination of accused by magistrate under section 313 CRPC, defense witness of accused and his cross-examination, argument, and then judgment. So there are total 10 steps. So I end this video here only. I will be giving you a second video on the various other aspects of check dishonor cases. If you have liked my video, please give comment and like my video, and please subscribe my channel. Thank you.